Welcome to the next episode of Small Business Chat. We got a lot of stuff to talk about today again. We got Marvel and DC losing some of their trademarks due to a challenge back according to July 24th. So we got a little cancellation on the USPTO side for the Marvel and DC trademarks. We also got Tiger Woods also suing a company for trademark infringement on his logo. Got a lot of stuff to talk about today. Matt joins me as well. How are you doing today, Matt?
I'm doing fantastic, man. We got a lot of juicy stuff, Tiger Woods and superhero Marvel and DC Comics. I
Quick,
mean,
Matt, I
are
think we talked about it in the other podcast. Are you Marvel or DC? I think you said Marvel last time we talked. It's funny, we
like
talked about this
you
podcast.
got the Marvel movies are just superior. Although I think most of us like I love the DC characters, Batman and Superman, but man, when they put them to screen, very rarely have they done it right.
Personally, I
What
think
about you?
I
Yeah.
think I think Marvel has a better line of movies, though, in my opinion, the Batman movies, like Michael Keaton movies, all of his, and then all of what's his name?
Christian
All of
Bale.
Christian Bale's
Yeah,
Batmans.
that was next level. That
and then
was great stuff.
the next Batman after him, which well, actually we're not going to count Ben Affleck because oof. But Robert Pattinson, I think did a really great job. He's also got another Batman movie coming out. By the way, Penguin just came out with his own movie on or TV show actually. It's actually supposed to be really good. I haven't watched it yet, but he's
I
got.
started watching it. It's good. It's
Is it
dark, but
good?
it's good. It's good. Yeah.
Okay,
It's
gotcha.
good. And it ties into, I think, the Robert Patterson Batmans, if I'm
Yeah,
not
that
mistaken.
ties in with him because Colin Farrell was in the Batman movie with Robert Pattinson. Yep.
Yeah, exactly. So, I mean, and you can't believe that the Penguin's played by Colin Farrell. I mean, what a great job of makeup and, talking about going to your, doing your craft and all that sort of stuff, making a really great looking guy look like that. You're good Lord, that's wild. But anyway, further on. So which one we tackling first here and how
Well,
can we bring this relevance out to our
yeah, I mean,
millions of listing people?
yes, since we're on the subject, let's hit Marvel and DC up. So I'm just going to read the article just to start everything off. So yeah, the cancellation, comes from the result of a challenge from this company called Super Babies Limited. I don't ever heard of them. I don't know if you have, Matt. A small company that produces a series of Super Baby comics about, well, superhero babies. Super Babies, created by S.J. Richhold, decided to challenge the two comic giants' claim to the trademark after DC attempted to block Richhold's efforts to promote the Super Babies, wrote that the law firm that represented Richhold in a release. Marvel and DC didn't respond to the challenge by July 24th, 2024, due date, resulting in the mark's cancellation, according to the USPTO's decision. As such, the office canceled four trademarks, the oldest of which USPTO's records show was for the trademark superhero registered in 1967, so quite a long time ago. The two companies still own a superheroes trademark registered in 2019, as well as a superhero villain trademark that was secured in 1985. So yeah, it looks like they just canceled their trademarks because Marvel and DC didn't want to respond to the cancellation.
Yeah, I think the first thing that's like fascinating is the fact that the word or words, depending on how you spell it, superhero is actually a registered trademark for Marvel and DC. Here's a little secret I don't think anyone knew about. Like holy crap, really? So they're the only two comic book lines that could claim superheroes for all these years, theoretically. That's impressive.
And I guess if anybody tried to use would it be if anybody tried to use superhero that they would have to talk to Marvel and DC for some sort of leniency on using that name
Yeah,
or
I mean, you have to get a license if you wanted to do it. I mean, that's and assuming that they had registered it for like, an animated series or, a series of motion pictures or, t-shirts or whatever. You would have to go to them if you were like, such. Now, one of the things though that we can think about though is I mean, you don't really call like how often do you think like if you've ever actually read a comic book, they don't with the exception of maybe some of the puffery on the outside of the comic book, they don't really call Iron Man like when you're reading like a superhero, in during the actual comic book. You know what I mean? Like, and it's funny. So it's sort of like it's like as made on or as seen on TV. Trademark is actually a trademark. And like the more I think about this, I'm like, well, maybe it's not that big of a deal because like you don't, superhero would be like advertising their particular characters, but in the actual actual stories, I just don't remember them calling themselves superhero all that much. Maybe sort of in the Avengers at the end. They basically like, Captain America and Iron Man's banter back and forth. They would talk about superheroes. But when you're actually talking about in US commerce, how often do you actually see superhero used like you'd see Coca-Cola or Google or something like that used, right?
Yeah, exactly. So I mean, so if I just thought up one day I wanted to make a superhero, and his name was Acer Man or something like that. I'm looking at an Acer monitor in my office. And I wanted to start selling some pop figures. I would have to in the obviously our superhero, I would have to contact Marvel and DC to get over ownership over having a superhero listed on my package.
Yeah, you would. I mean, back in the day, but now it's canceled, as we're aware, right?
That's awesome.
So
Okay.
presumptively, because it's generic, would you think? I mean, we didn't read, sorry guys, we didn't actually read the actual pleadings. But I'm assuming it's because it's generic. What else would you cancel it on? You know,
Yeah, so I mean this but how can it be kept for so long and then just be canceled like this?
because no one brought it up. Then one of the one the Patent and Trademark Office does not have the mechanism, shall we say, for the most part, to cancel trademarks. You need somebody outside to actually do it. Like and have the like so for instance, a couple of years back when, political landscapes change and all that sort of stuff, and the Washington Football Club was now the Washington Commanders, but obviously they were previously famously for many, many decades named the Redskins, right? And the Patent and Trademark Office, even if you had like a term that is now considered to be racist and maybe it was always considered to be racist, forgive me, I'm not trying to be racially insensitive here, but they won't spontaneously typically take action. I think they possibly have that in their wheelhouse now that I think about it, but usually it's for like a procedural screw up or something like that. But they're not just going to comb through their own records and basically be like, wow, that's a racist term now, so we're gonna do whatever. So they had to rely on a group of Native Americans to actually continuously bring an action to actually remove Redskins as a federal trademark, of which they were eventually successful. Um, but so coming back to this, Patent and Trademark Office is just not going to sweep off superheroes because someone else believes it's generic. Someone else actually has to bring the action. It sounds like someone did in this case, and Marvel and DC was just like, it's not worth fighting, and such. Which, it's by the way, what is generic? Do you remember what a generic trademark is, or really not generic trademarks? What is a generic term?
Yeah, so if somebody had a business and they were trying to trademark Kyle's Amazing Cookies, that's a shout out to KG. But Kyle's Amazing Cookies, and I try to operate a business underneath of that name, that would be generic because I'm using cookies, and I also sell cookies in my store.
Right. So like the actual part that's actually so when the actual term refers to the good or service itself, or actually not refers to, is the good or service. Cookies, in this case, for cookies would be generic for cookies. Shoes for shoes. Movies for movies. So I think what the argument would have been here is that, it's about superheroes, or maybe it was just so descriptive, but I don't know. But I mean, so superheroes could that actually be generic or something? But although now that I go down this rabbit hole, to the best of my knowledge, we don't have actual superheroes. So wouldn't it be fictionalized? And if it's fictionalized, why would it be generic? It would actually be descriptive of a fictional character. But we'll just stick with the generic thing for now. If you have something that's actually generic or has become generic to refer to a class of hero, which is superheroes, then I would imagine it would be maybe that's potently why they did not go, and try to sorry, not potently. They didn't try to actually oppose this cancellation proceeding because they're just like, yeah, just let it go. What do we really need? Who gives a crap? We're not making any money off of this. So why go spend $100,000 to defend it? And actually, their lawyers would probably charge more than $100,000 to defend the case. For what purpose? So you can be the only people that say superheroes? Who cares? You're not really making any money off of that.
Okay, so I mean, I guess so to them, I guess again we didn't really read into this, guys, but I mean, with the actual ruling itself, but I guess they just didn't really care about it, in a way, because again they
Yeah,
didn't.
they did something. From what we've sort of just read into a little bit, that DC and Marvel didn't actually oppose the cancellation. They just let it, default, and then they removed them from the rest. So in essence, what this is, and we've recently actually seen this. Sorry to get political, but this has happened recently with all of the Trump cases and these civil cases brought by New York, and such. But it's called the default judgment. And for our listening audience out there, we were straying a little bit from trademarks, but effectively, if you get served with some type of lawsuit, it's usually civil lawsuit. You get served with a criminal complaint, you don't get a chance to just default. They will, shackle you up and drag you into court to have your day in court because we still have a jury requirement and all that sort of stuff. But when you're talking about a civil lawsuit, which is what Donald Trump recently dealt with this whatever falsification of business records and all that sort of stuff. Not the Stormy Daniels one, but the ones on his for the loans and all this sort of stuff that he owes the state of New York all this money. They just defaulted on the original case. So it's, and such. And so that's why the state of New York got a quick, easy judgment against him of he was found civilly liable for all this business fraud or whatnot, because his lawyers, for whatever reason, decided we're not going to defend the case. Likewise, these Marvel and DC lawyers decided we're not going to defend the case. So when you decide in a civil level, we're not going to defend the case, you have maybe 30 days to respond. If you don't respond within 30 days, the court has within its power, depending on the applicable rules of civil procedure, to say, okay, we find you in default. Where the person that brought the case wins by default is what that means. And so this both happened in the DC Marvel superheroes case. And I'm not trying to get political about this. I've gone too deep in this. It's just the only famous case that I know about recently where this has happened, where Trump's lawyers either advised him or just didn't show up. We don't know what happened, but decided not to defend, a couple $100 million lawsuit filed against them by the state of New York, which to me still baffles my mind because I'm just like, they probably could have dragged it out for years, but instead they literally took a judgment. And then, so by the time they went to defend it, just telling everyone what actually happened in that case, sorry, it's just a damages thing. So you go on to the second phase, which is what are the damages? And then they try to defend on the merits at the damages phase. And the answer is the judge is like, you can't do that. You defaulted on the actual liability side. So it'd be sort of like, imagine for saying like the Marvel superheroes and all that sort of stuff, they defaulted and then they want to say, well, but we still want to use the trademark. We want to keep it registered. And the answer to them is, but you defaulted. So they made the decision evidently to just go ahead and default. It gets taken off the books. So don't default on a case if you don't want to just to lose it. And once again, Trump recently did it. Still can't figure out why the hell they did it. It's and then try to argue against the damages phase, which you already been held liable. In any event, let me get back on the superhero thing. Don't default judgment. And also, if your trademark becomes generic, someone can take it away from you, right?
As seen,
that was a lot.
yeah, as seen in this ruling. So I guess this is good. A good topic that we discussed right now about how to not have your trademark be generic. So
well, right, and then just to briefly touch on that. So for where this can be applicable to two points that we can bring out of this for for generally in business. Okay, number one, if you get sued with something or whatnot, you can't just stick your head in the sand like an ostrich and hope it goes away, because they will issue a default judgment against you. And again, you can make the decision to stick your head in the sand like an ostrich, but understand that default judgment's coming, because it's called process. And that's what we have in this country. Whether it's fair, whether it's not fair, it is what it is. So that's the first thing you can take of it. Number two, it's what they call the paradox of genericness. And I haven't mentioned this one, but I'll just briefly touch on this real quick. You want your business to eventually grow, so it's making millions and millions of dollars and you're doing amazing and yada, 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 yada. But what happens is the more that your business grows, what happens if your trademark starts becoming a verb? We've mentioned in this in previous, podcasts, Google. When people say Google it, well, that's not using Google as a trademark. They're saying search it on the internet. It's a very dangerous paradox that you can actually see, is because you've become so famous that does your trademark that was originally inherently distinctive become transcendent, and it has actually moved towards being a generic trademark for the industry. Google it meaning search it on a search engine, not actually meaning go and search it on Google. That's a big challenge for companies like Google, etc. So did the superhero trademark just become so generic over the years that they're like, they're going to be able to pull out 1 billion articles about superheroes that shows that they weren't just referring to DC and Marvel comics, but tons of different stuff. We're not going to actually fight this one. But for a brand holder, just know you've got to continuously enforce your trademark against people who are using your term in a generic manner and not to refer to your brand in particular. Because if you don't, you can risk the fact, your trademark becoming generic. famous examples would be Xerox for photocopies. That's one of the ones that they teach you down at the Patent and Trademark Office when you work down there. I think Google has always been in danger of that actually happening to them. Trying to think, can you think of any other ones, Jacob? Now that I think about it, they've become generic. Xerox is one of the big famous ones.
None come to necessarily mind right now.
I got another one. Sorry to interrupt. Rollerblades. That's an actual trademark. Inline skate is what the actual thing is. If you remember, do you remember rollerblades when you were a kid?
Of course, I still use them today. I'm just joking.
Yeah, you still, that's how you got to work today. All 60 miles of your commute. You just grabbed onto the bumper of an
Man,
18 wheeler and
yeah,
all your
that
hair is always swept back when you
that
get in the
took me
office.
10 hours to get here.
Yeah,
Yeah.
that's amazing. No, but yeah, so that's just like, so you want your trademark to become really, really popular, but that's why we enforce our trademarks, even when it's not direct infringement against improper use in the marketplace, especially if your trademark starts getting so popular that it, you have a risk of it becoming generic. And again, I think that may have been what happened to the superheroes thing here. So there's two little tips out of the actual news that our consumers can actually use.
Awesome, awesome. Well, that covers it. We covered again the Marvel and DC dispute, and well, not dispute, but challenge that was given to the other company, and now everyone can put superhero on anything and feel confident that they don't have to pay anyone else to use superhero on their products. So that's good in case you come up with some sort of product. I don't know, Matt, if you could make your own superhero like doll or superhero in general, what would you name them?
Put me on the spot.
You already know
I'm
mine.
sorry. I
Mine's
thought you
Acer.
were going with a different thing. If I could make my own, what would I name him?
Mine's
Wow, that's
mine's mine's Acer, man. He just flings he just he just flings computer monitors at people.
cheap computer monitors and everyone. Sorry, I love my Acers, but that's why we have them throughout the office, which is because they're affordable computer monitors, which and they work great, man. They're like 20
Yeah.
years or 10 years old, and those things all still work great. They'll shout out to the, Acer and Acer man now, which,
Acer and Dell are my top two favorite computer and monitor brands.
okay. I used to, okay, well, yeah, okay. No, we don't have enough time today to go into I do have a bone to pick with Dell, but for the most part, I think Michael Dell created a hell of a company back in the day. But I will say they used to have this, well, very briefly, they used to have this thing called the Dell Gold Team or something. They would call me up and they'd be like, okay, yeah, well, I'm having this problem with this server or something like that. And they would basically just never call me back. And what you realize is they were just trying to sell you stuff all the time. I'm like, dude, don't come to me and basically be like, we're a product support team and stuff. We're the gold team because you've spent so much money with us and yada, yada, yada. But then really you're just masking as a sales team. If you're going to be a sales team, just tell me right down the middle. Hey, I'm coming to sell you something. But what I would have suggested them at the time is you provided me a little bit, if you would have provided me with a little bit of customer support vis-a-vis a problem I was having with one of the products that you actually sold to me, I would have been a loyal customer for 20 years. The reason why we have Acer monitors is because the Dell Gold team, in my opinion, wasn't gold.
Gotcha. Well, all I
Sorry.
can say is, this computer that I'm currently using right now is my favorite computer I've ever had, and I've always pretty much stuck with Dell ever since I think my first Dell I've got when I was a teenager. So, pretty much,
There you go.
I usually typically try to stay away from like maybe sometimes HP. I've also tried Samsung before, and they just don't make the greatest computer in my opinion.
Yeah.
But in other news, trademark infringement upon Tiger Woods brand Sunday Red. There's the other company, and I'll read the article here.
Yeah. So Woods is actually, they've opposed his trademark. So it's
Yeah,
Woods
so
that's the ones in trouble.
yep. So
Right.
Sunday Red, the apparel and lifestyle brand that launched in February by Tiger Woods and TaylorMade, is in a trademark dispute with Tiger Air, a company that makes cooling products for athletes over its logo. Tiger claims that, okay, wait, actually, I have it backwards. Tiger Air is the one that is claiming that the Sunday
Correct.
Red logo, which is depicting a 15 striped tiger, closely resembles its leaping tiger trademark logo, and that could create confusion for customers and violate Tiger Air's brand identity. A court filing from Tiger Air states the actions of SDR TaylorMade and Tiger Woods blatantly ignore Tiger Air's long-standing protected mark, brand identity, and violates federal and state intellectual property law and disregards the customer confusion their actions create. SDR's application should be denied. Tiger Air has registered his logo with the U.S. Patent and Trademark Office since 2020 Among the products of the Baton Rouge, Louisiana-based company sells are wearable air coolers, fans, and air conditioning systems for football helmets, including those used by Louisiana State University.
Yeah.
So,
Yeah, there's
um,
there's that.
so yeah,
I
they're
often
fun.
I was actually thinking about this recently. I was literally watching like one of those games that yeah, I'm just like, it's where was I? Oh, I was at the Ohio State game the other day. And it was shockingly warm for Ohio State in mid to late September. I think that, and Ohio State plays on turf. And again, I was just thinking to myself, I'm like, man, how easy would it be to put in just like an air cooling system into shoulder pads, or a helmet, or whatnot. I think helmet's a little bit, well, more challenging because it's so much smaller. But I was just like, it would be so much such, because I can remember um there was once, like so if it's 90 and you're on turf, I mean it feels, in the bright sun, it feels like over 100. I can remember once I was playing a game down at the Swamp in Gainesville, Florida, and I think it was 98 degrees. It was a noon type thing. And I think you remember the old big dial, like the thermometers and such. And I think it was reading like 100. I swear to God, it was like 125 field temperature. And you're just like, this is not cool. Like literally, like it's just Dutch or whatever. He's like, this sucks. So I'm glad that someone actually invented this stuff for the LSU. But have you seen the two tigers? What do you think?
For one, I actually really like the Tiger Airs logo better than the Sunday Red. I think a child could have made the Sunday Red logo for the Sunday Red logo.
Yeah,
I mean, they're both going in the same direction. I'm looking at them side by side here. They're both going in the same direction. It looks like they're both leaping. But I mean, they have nothing of the same name. All they really have is just the Tiger leaping. Tiger Air does cooling things for helmets and other products like air coolers and everything, wearable air coolers and air conditioning systems for football helmets. So, and then on Sunday Red, obviously they sell hats and golf attire and everything. So I personally, I mean, you'd have to go after anybody that uses that Tiger going in that direction, right? I mean, if you're going to go after this. So I personally
yeah.
don't see it too much as a trademark infringement, just because again it's just a generically used tiger, and they're not taking away the name or anything either. They're literally just calling themselves Sunday Red. So what do you think?
Yeah, I'm looking at this, and I guess in theory, the simple answer would be is how many people have, let's just go a little bit broader, the depiction of a tiger in any form, any shape, or whatnot, in connection with clothing. And is there more than one or two brands that have tiger? And I'm just thinking to myself, well, this whatever this company is that's doing, I mean, the first cross exam point I would bring up, the fact is, oh, so you develop your products for LSU, yeah? Does LSU have a tiger on their logo? Oh, they do. Do they make clothing? Uh-huh. Is it a registered trademark? I'm gonna tell you right now it is. Yeah. So you don't have a problem with them, huh? So your problem isn't with generally just them having a depiction of a tiger. You're saying that these two tigers resemble themselves way too much for Tiger Woods to have. Is that correct? Yes. Okay. So now we get past the point that's not just that they admit, or they will have to admit at some juncture, because I can think of, I'm sorry, just looking, my alma mater plays Princeton on whatever. Princeton's called the Princeton Tigers. They got tiger on their logo. They have clothing. They have a trademark for it. I'm trying to think how many other tigers are out there. Memphis Tigers. I mean, you just think you can go through just the litany of colleges alone that have tigers in them, not to mention, other, the Detroit Tigers. And Detroit, the baseball team, the Detroit Tigers, I think,
Detroit
right?
Tigers, yep.
Yeah, I guarantee you they have a tiger mascot logo, and stuff. So now, so you chip away at what their argument can actually be, and looking at their pleading is, well, no, it's the way it's outstretched and all that. So okay, we get you, but that's fine. But first of all, I mean, if you look at the back line is completely different from the two. The one swirls up a little bit more, the other one swirls like when I look at the two, I don't think of, well, first, I don't know their line at all. And to be candid with, I don't know Tiger Woods' new line at all either, because like I said, it's brand new. Um, but they can't claim exclusive rights to having the depiction of a tiger. So then you're going to be down to the really hyper subtle of, well, how close do these two resemble each other? Like, and are people actually going to be confused? I can be honest with you. First of all, I don't think either logo is great. I think they both sort of suck, in my opinion. Sorry. When you think of the iconic, Nike logo where, Tiger Woods started, and then his TW logo, which I would have thought would have just been his and he got to keep. Maybe, Nike owns that too. Who knows? But to this new leaping tiger thing, I don't know. I don't like either of them, but I certainly don't think it's infringement, and I don't think they're going to win the opposition. And I'll just tell you, in my opinion, um, it's usually an uphill road to climb because, I got to try about, we'll just say many cases before the Trademark Trial and Appeal Board, and I always thought that there was a bias. I mean that respectfully, to the more famous brand owner's brand. So in other words, if you had a small company coming up against a mega company, even if the small company was the one saying, "Hey, they're infringing on my brand," and maybe I just was not a very good lawyer. Who knows? Maybe that's what it was. But I always thought that when we had a relatively good case, I obviously had mistaken you know, my case. So in this instance, I would say first, putting it in a vacuum, I don't think there's infringement here. Second, knowing what I've, seen from the TTAB over the years, back many years ago when I was in front of them, I've been there in many, many years, but I would assume there's going to be some sort of, hey, belief that, well, hey, well, hold on, let's take a look for Tiger Woods here and such. By the way, I'm not suggesting anything improper. I just don't know how they actually, come up with these sort of things. But from my experience, it was just, the fame of the brand owner or the fame of the brand owner somehow played a role in it. And then perhaps something that maybe I just never grasped.
Since we're talking about tigers, Matt, this is a very random question. What is your spirit animal?
My spirit animal? Man, you got these, you're stumping the panel today. I don't, what's a spirit animal?
You know what a spirit animal is? It's the animal that best resembles you as a person. So my spirit animal is a lion because I'm brave and I have a ferocious attitude. What is your spirit animal?
Oh, wow. I would have no sloth. No, I don't know. You know, uh,
Not that slow.
no, but yeah, no, but no, I don't know. I'm sure it'd be something. I just don't know if there's an actual thing where you can actually go and find what your spirit animal is.
No, I thought it's always been around forever. Yeah, everyone has a spirit animal. I guess we'll put a pin on that one, Matt, and
Yeah,
I'll
put a pin
ask
on
you
that. I'll
about it.
find out what my spirit animal is for a
I'll put
future discussion.
I'll ask you next podcast if I can remember. So
Yeah, that'd be cool. So, coming back to Tiger Woods, I'm sorry I just blathered on twice here today about this sort of stuff and the TTAB and all that sort of stuff. They're good judges and they decide things very fairly and all that sort of stuff. And they always they have actually a really cool job at what they do and all that sort of stuff. But in my opinion, it's just not infringement. But we'll see what the TTAB does with it. Good luck to both sides, etc. I'm sure Tiger Woods isn't losing too much sleep over it because of the amount of cash that he has. It's, whatever, and such. But, from our perspective as we, speak out to our small business people, it's just once again a reminder that it doesn't matter if you're a small business or someone who is one of the greatest golfers of all time, you know, and someone has a right to oppose your trademark, and unfortunately, it's going to cost some money on legal fees. But this is why you do a really good comprehensive search in advance to try to make sure that there's nothing out there, no one out there that your trademark's going to infringe on or anything like that. And I am, I can be honest with you. I know Nike's lawyers. I used to try cases against them before the TTAB. I know I had one or two against them. I don't know who Tiger Woods would be currently using, but I can guarantee you they're gosh darn good lawyers. And I'm sure that they would have reviewed and made sure that, in their opinion, there was no infringement because they wouldn't advise Mr. Woods and whoever the muckety mucks are at their new place to go forward with this logo if they thought there was an issue. So there's going to be some good legal representation going on both sides on this. But to try to avoid this sort of stuff, make sure you do a clearance report, and then again, coming back to our other issue with the superheroes, don't default if someone actually files something against you and you actually want the logo. You don't want to default on it, and then get some help with a lawyer that can actually help you navigate through this stuff and such. But hopefully you don't ever have to deal with it, like Mr. Woods is having to deal with. He's had to deal with worse in the last 10 years. But
Yeah,
great golfer.
you digress.
I
uh,
digress. Well,
awesome.
he literally lives like right near where I like grew up. And like the bar that that I think is, or his restaurant, is literally in one of the places I sort of used to hang out, like right in that area. And I've been told he actually used to, for a while, that's his former girlfriend. Like you would just you actually go into his restaurant, just like sort of hang out with him. He's actually really, really nice, really chill guy, and all that sort of stuff. Unlike other sports stars that live down there, sometimes are a little bit standoffish. But I've heard he's actually, I've heard nice things about Mr. Woods. So good for him.
And Matt mentioned before comprehensive search. Here at the shout out to the Trademark Company, we have a comprehensive search service that we offer to all of our customers. So if you want us to do an in-depth analysis of the USPTO's database, just to see what's out there, and also we do our system does detect if your trademark has the chance of being descriptive. Which could help you out in the long run with filing your application. We will give you a search report. We do offer it for $299 in our fees to perform that service. So, head on over to the Trademark Company after watching this or listening to this to go ahead and start that search now. So I've had a couple of customers that I actually had a customer the other day that wanted us to run a search report, and they're very thankful that they were given that search report, given what's out there. So come on to the website as soon as you'd like to go ahead and see if you have anything that could be descriptive. We'll check it before you even file it. So I think that's all I have. That's all I have for myself, Matt. Is there anything else you'd like to include?
No, thank you so much for bringing me in on this one. I appreciate it again, as always.
Yeah, no problem. Thank you again for all that's listening. Again, this episode is sponsored by the Trademark Company, and we hope you have a great week.